Hi, Velma. Okay, then. So this is really crucial, I think, actually. So this is the 1688 Bill of Rights printed out. There's another bit on the bottom of it, and that is the part about the consent, Lord Spiritual and Temporal in Parliament, etc. So that's the bit that I'm put on there, but I just wanted to just lay out in how it's. I just wanted to examine how it's laid out and the order of it in order to assist for interpretation now that we have got all of the context and intentions and purposes of it, which clearly is actually a judicial process for the public, which is a proper judicial process for the public, but to Parliament, also with proceedings taking part in public, obviously because it's a slightly different format than court with a jury. You get the public to support it first, and then it goes into Parliament for debate, and you don't even have to have a Parliament, actually. It can be looked at. I think that's probably why they had the justices and the grand jury looking at it if it was to the king and so forth, particularly if they hadn't even called a parliament. This is more important than electing MPs to represent us, because this is for if they didn't call a parliament, and also as well as parliament to make your MPs do things for you, or if you're in the parliament, direct to the king and so forth. So what I want to, the main thing that I want to point out now, when we've got this additional knowledge, is the layout of it. So with the modern acts, with the new acts, right? They have the coat of arms at the top, and then the title, and then it starts with usually with the consent of Lord Spiritual and Temporal and the presence hereby, etc. So the opening bit of hereby is given with the consent of Parliament, blah, blah, blah. That is the opening piece on the modern acts. But with this act, that bit is at the bottom here, right? The consent, if you type in the word search for consent, what gives the consent for us to have these rights and use them, that's at the end. So they've changed the order of the layout of it has been changed, right? So that's important. So that part with the consent and so forth is at the bottom on this one, right? So what I've pointed out, I've put a red spot there, and I've put a pink spot here, right? Red spot and a pink spot. And I've highlighted in this section here with the pink spot, I've highlighted this article here, and in the area with the red spot, I've highlighted that article there. So I've got these two important articles, which is referring to the immunity, right? And then I opened a search box for judges and ministers, right? And it mentions judges and ministers here, which is for evil judges and ministers, right? So it's actually about, judges or ministers, members of parliament. It's the only time it mentions judges or ministers, that's our representatives or the judges, is in critique. So it's actually mentioning them evil, which, it's a bit of a arcane, dogmatic or arcane word, evil. We'll just replace it for now with naughty or bad, right? So naughty or bad judges. Well, you only have naughty or bad judges if they're prosecuting you illegally, usually, or wrongly, or if your ministers aren't representing you properly in Parliament or are misrepresenting you, right? because they didn't always have a parliament with ministers. But you've got the ministers in the functions of different departments of the government, and also the operations of government. So it only mentions them. The only time it mentions government or ministers, really, if you type in judges and ministers, is in reference to them questionable behaviour, being naughty. So the whole context of the only time it even refers to the judges and ministers is when they're being naughty or bad. Now, they can only usually be naughty or bad to us. So, and this whole act, therefore, isn't really for the judges or ministers. It's not for the judges or ministers, and it's not for any rights or immunities, really, of judges or ministers, which means it's not really their immunity, and it's not really their right. And we know that now from the other piece why this was enacted was to protect the voters, the people, the subjects, the citizens, when they're engaged in these proceedings to Parliament and covering their activities both in public and through the proceedings, which is confirmed by Karen's work. But it is a proper legal process, a judicial process. I would suggest that those judges or jury were, if you hadn't actually got a parliament and you were petitioning the king directly, then they would be able to check things through and process it. This is what I'm starting to tend to think now. But the thing is, right, so what even is this act? What even is this act? So the first opening bit should set the entire context for the act, and that is that an act declaring the rights and liberties of the subject, that's us, and the settling of succession of the crown, but the rights and liberties of the subjects. And that's why I've put a red spot there, because this means that this is about us. It's about the people. And we've got that confirmed from Karen's work and from the witness accounts from around the time and the type of things that we're doing. So it is an act all about us. It's not actually really anything to do with the rights of judges or ministers. In fact, when it only mentions them, it's questioning their behaviour, both ministers and judges, right? Now, what confuses some people have misconstrued this to mean that this first part here, because it talks about judges and ministers and illegal prosecutions, I've highlighted this here, illegal prosecutions by the King's Bench for matters only decidable or debatable in Parliament, right? That's why I've highlighted that. The title of the article is illegal prosecutions, right? Now, this is like, we need to get this in context of like framework and layout of the act. What's confusing, I've put this pink spot here because it says the subject's rights. The subject's rights, that's the title and starting point here in pink, the rights of the subjects. Then it goes into this. This is not just... This doesn't mean that these are the subject's rights, our rights, and nothing else. It does not mean that. This is just the subject's rights written out, itemised, right? The subject's rights. But the whole act is the subject's rights and liberties. That's the point of the act. That's why I've put it in a red spot. It starts off here. That's the point of the act, right? But we start off with, what are the subject's rights? But then we've got after it, we had with consent of Lord spiritual, so it be enacted and so forth, which usually that, like I said, is at the start of all modern acts. They have that bit at the start, with consent of Lord spiritual, blah, 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 so it be enacted. That's the opening bit, which... on these, that's at the end. Now, so if these are setting out our rights, the subject's rights and listing them, but the whole piece is these are the rights and liberties of the subjects, which is the title of the entire act. That's why I put a red spot there, because that is what this whole thing is about. So how do we then see this first section here before we get to listing the rights itemised? Well, how I'm starting to see this now is just giving a bit of context to it. Giving a bit of context and meaning and interpretation to help us when we're understanding the subject's rights. So, therefore, what I now see this part as here, right, is if you look at the modern acts, and particularly like we've looked at the Town and Country Planning Act and the statutory instruments, right? What they normally have at the end of the act, right at the end, after all the schedules, right? They have the explanatory notes. And the explanatory notes are there to give context to, clear up any confusion, and explain the meanings, just so to make sure that you understood the act properly. And those explanatory notes at the end, what they do is they aren't to be misconstrued as the as the clauses of the act, but they're there to help clarify, right? And they're right at the end. But at the start of the act, you have the opening piece with the consent of Lord Spiritual. At least you have in all the acts that have the coat of arms on, like the Town and Country Planning Act, but not the statutory instruments, because the statutory instruments is an update to that act. So it's additional law which adds to the Town and Country Planning Act, which does have the coat of arms and the enactment, right? So therefore, if this is in a slightly different order, because it's old-fashioned from 1688, it's in a slightly different order and sequence to what we have these acts now, with the coat of arms, and then so it be enacted and so forth, and then you go into the law, and then you have your schedules and explanatory notes at the end. What we've actually got is the coat of arms, the opening piece. It tells you what this is about. This is about declaring the rights of the subjects and settling the succession of the crown. But definitely the main thing is, it's not about the rights of judges or ministers, no immunity of government staff, really. In fact, the only time when you search for the words judges and ministers, like having this little search box, is here. And the only mention it gives of them is if they've been naughty or breaking the law. Evil judges and ministers, right? So it's about controlling them so they don't do naughty things like prosecutors illegally. So this opening bit, I believe it is setting out the context and the meaning and the definition. We've got the settlement of the crown and so forth. But here, these illegal prosecutions, right? So these two bits that I've highlighted. So I would say that this illegal prosecutions clause here, it's telling you about illegal prosecutions, and it's giving you some context and explaining legal prosecutions in context to the act, so that when you get to the subject's rights, which are here set out for us, we know how to apply them, and we know what they mean and what context they're in. And then after this, then make it official, and then so be enacted with consent of Lord Spiritual, the King and Queen, and blah, 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 which is the end bit, which is usually at the start now. So the right to petition, this is under the subject's rights. So here are our rights. But the act is about our rights and liberties and nothing else. Well, except for the succession of the crown, but it's not the liberties and rights of, staff of government or judges or police officers. It's us. Now, so it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. So it's about being prosecuted illegally, right? It's about being prosecuted illegally when you're petitioning, and us, the subjects. So the other place, so we want to know about illegal prosecutions. What about them? All right, see, it's illegal to be prosecuted, but what about legal prosecutions? Well, it tells you about legal prosecutions here. This is telling us about them. Illegal prosecutions. What about them? Prosecutions by the court of the King's Bench, right? For matters that are only decidable, debatable, and thinkable in Parliament, right? And it's talking about illegal courses and methods and ways and routes, which is basically about, being, lying, basically. So this is what we need to know. We need to know about illegal prosecutions. This is not some other law that applies to different people, like, elected MPs or judges or staff of government, because the Act is about us, our rights and liberties. This is our Act. That's why I put a red spot there, the whole thing, and the succession of the crown, but it's us. Here is the subject's rights when it sets them out, and then, like I said, afterwards you've got that bit that's usually at the start. So we need to know about illegal prosecutions. What about them? This is relevant. Well, the thing is, when you're petitioning the king or parliaments in proper legal proceedings, which we've absolutely confirmed that they are legal proceedings from Professor Karen's work, and they used to have justices or a grand jury involved, particularly if there was no parliament called. Even if there is or isn't a parliament, it's still our rights to petition the king or parliament, depending on if there is one or not, right? What about them? Well, illegal prosecutions by the King's Bench. Well, the King's Bench is the judiciary. Like the Queen's Bench, is the Royal Courts of Justice, is the highest court. So it's the judiciary. Because the judiciary prosecute, right? And when we're petitioning Parliament, we're not actually prosecuting anyone usually. We are wanting an action or something done by the King or by the Parliament, a law making or changed. It's bringing proceedings to the Palace of Westminster. Well, the King's in the Palace of Westminster anyway, in the House of Lords, right? So, illegal prosecutions by the King's Bench is the judges. The King's Bench is the Ministry of Justice, the judiciary, all the judges, right? When we're bringing proceedings to Parliament. Now, the thing is that if there wasn't a Parliament called, there wouldn't be no ministers representing us. So we would be ourselves bringing a case, and it would get checked by justices we couldn't be prosecuted by, or a grand jury just to check it out and so forth, for the king, right? But if there was a parliament called, then we're petitioning either of the houses and the ministers, and they debate it for us, right? Now, because they're debating it, they're elected full-time to represent us in Parliament, they are presenting our case and they are debating supposedly on our behalf, and that's why we elect them. So they would be presenting our casework, so they would be immune because they're elected by us to represent us and our will and our matters, our cases and so forth, full time. That's their job. But also, the House of Lords has to check everything through as well. Legislation goes through both houses. It has to be approved by the Lords and signed off by the King. Now, the peers, the Lords and Barons, are lifetime peers. So if you get made a Lord or a Baron, that is your job for life. You're a lifetime peer of the House of Lords. Elected MPs are only elected for a term, but they're doing the work that we have supposedly asking them to do. Now, when we're petitioning, we're doing work for Parliament. We're getting matters to Parliament and getting the evidence of support of the people. And so we're all involved in the same process when it is for bringing cases to Parliament. That is us. So it's us, our elected MPs or the Lords. But like we said, there wasn't always a Parliament. They didn't always have a Parliament or call it. So we didn't even have elected MPs and they weren't even assembled. So therefore, it's us getting it checked off by the judiciary. So we don't even have the MPs at some stages, and in fact, you can petition for them to get some MPs together and have a Parliament as well. That was one of the main things you could petition for, to get them to get the Parliament together, and so forth. So this illegal prosecutions here is, I believe, for clarification and explanation about this clause, right? Because the whole act's about us and our rights, right? Now, the thing with... So we have our petitioning and casework is in connection with Parliament, because it's not going to a criminal court or a civil court. It's cases to the Palace of Westminster. Even if we're out of Parliament, it's preliminary proceedings for that. Just kind of like the police, whenever they're chasing criminals, it's preliminary work for a criminal case. This doesn't even really give the police. So what this says is, it is the immunity against illegal prosecutions is really only for matters concerning Parliament, when we're bringing cases to the Parliament. It's not even creating immunity really for police or lawyers or even judges who are doing criminal or civil proceedings. This is definitely not immunity for judges. And the only reason that ministers would have immunity is if they are, they're elected to represent our interests in Parliament, as the peers are meant to be permanent doing that. And then we just do it when we've got a particular case that we want to bring, or in elections and so forth. So I don't actually think this is any immunity for particularly the police or lawyers or judiciary or so forth. I think it's the people's immunity, or anyone involved in this process of initiating, going about proceedings to the Parliament, actually not to the courts. In fact, it's illegal for the courts to get involved, because the only way the courts really could get involved is if they were prosecuting you or something, because that's all courts do really, or give fines. Now, the only other... Now, there's probably some other statute laws that possibly maybe do cover the judges or judicial processes immunity, but I think it's possibly been misconstrued and misunderstood. And I actually believe that if you go back to Magna Carta, which apparently was cancelled, there's debate over whether Magna Carta is valid or whether Magna Carta is not valid, is with the barons. So the barons, what we've got in Magna Carta, right, which is a lot earlier with this King John, it says that the only immunity clause in that is that the barons can only be judged or fined by their equals, which means that if the barons they haven't got immunity. It means that the barons and the lords only judge each other. So, almost like a rank thing. They can prosecute each other, but only, they have to be prosecuted by other barons and lords. It doesn't actually give them immunity. It doesn't actually say that prosecutions are illegal against them either. It just says that, barons and lords only prosecute each other. It doesn't even say judges or ministers either. It just says barons or lords. So that doesn't mean that it's illegal to prosecute them. It just means that we can't judge them. They have to be judged by their equals, right? So that's really important. So with this, in fact, it says that if we are petitioning the government, and that's what we're doing, engage somehow, whether in public with preliminary or with the debating part that goes on in the Parliament part of those proceedings, and when it gets there, debating it with our elected MPs, or if there isn't a Parliament, if we do it directly to the King, and whether it gets checked by the judges or judiciary or not, but obviously that's been abolished now. They don't have it. You don't have to have it checked by a lot of articles. Then we're prosecuted. You can't be prosecuted. Sorry, it's immunity, or at least you can't be prosecuted by the King's Bench, the judiciary, right? So, well, it says it says illegal prosecutions by the King's Bench for all matters decidable, cognisable only in Parliament. So illegal prosecutions by the King's Bench. So, is that the King as well and his judges, or is it, can you be prosecuted by the King himself but not the judiciary? Well, that's setting out. This confirms that the matters that we are petitioning about are going to Parliament and will get debated in Parliament. In our clause here, the right of the subjects, it says that all prosecutions are illegal. All of them. All of the prosecutions, all of them. So that is complete and total full immunity. Unless you add this context to it, can you get prosecuted by the King himself? Or does the King's Bench, if it's the King's Bench, then surely it's him, the King, sits on the bench, and all the rest of the Ministry of Justice, all of the judges and judicial. But this is definitely only for the proceedings that are being brought to the Palace of Westminster, the judicial process, not to any other court, not to the King's, but not to the Royal Courts of Justice, not to the Supreme Court, not to the Crown Court, not to the Magistrates Court or the County Court, but petitioning the Palace of Westminster, the Houses of Lords and Houses of Parliament, and the King, who obviously sits in the House of Lords. That's where the throne is. So if there is a Parliament, if they dissolved Parliament, then the King would be, there wouldn't be the Palace of Westminster. He would just be at his, Blenheim Palace or wherever, or, Windsor on the throne without a Parliament. I guess, then you're going direct. That's the context for the time. Now, one thing I'd like to just add to this in context of modern law, if you look at the Human Rights Act, but not at the articles, if you look at the Human Rights Act through the sections of legislation, like, Section 1, Section 2, Section 3, Section 4, I don't really read it by the articles, because the articles are very simple and just, very, very simplified principles. If you go into the legislation, into the sections, you'll find in Section 6, Acts of Public Authorities, and in Section 6.6, which is quite, it's not 666, because that's 666, but it's 6.6. It's purposely put at 6.6. That means something. It's 6, then 6. It distinctifies anything that is done in connection with the Parliament. In connection with Parliament is regarded as different or separate to any acts or authority of the local authorities, right? Which also includes the local courts and judges, because if something is in connection with Parliament, it's intended for Parliament, it's destined for Parliament, its purpose and procedures are in connection with Parliament. Now, petitioning Parliament, that's in connection with Parliament. So again, it highlights that there is things that can be done that are in connection with Parliament that are distinctively separate from the rest of the authorities, like the police or the local council or the councillors and so forth, right? And also in the Human Rights Act, section 7.1b, it says that you can rely on these rights in any proceedings as long as you would be a victim, of the act. Well, if you're going to be prosecuted illegally, you're going to be the victim of an act. So in section 7.1b in the Human Rights Act, you can rely on this right to petition in any proceedings. Well, what proceedings would you need to rely on it for, other than, to make sure that you can actually do the petition and submit it and get it debated, other than if there was some issue with proceedings being brought against you, like, through the courts, which would be legal prosecution, which is really the only reason why you'd need immunity, is if they were bringing prosecution against you from the courts, which, illegal prosecutions by the King's Bench are illegal for matters that can only be, that are being addressed to for debate in Parliament. So this is adding context to this, although this from the subject's rights clearly says that you can't be prosecuted at all. So that helps define the context of this, illegal prosecutions by the King's Bench. Well, it means the judiciary. It means the Ministry of Justice, the judiciary, the judges. So maybe the King can convict or prosecute you. I'm not sure. That's questionable. But what this means for certain is that this is not even about judges' immunity or government staff immunity, really ministers. Because what ministers are really is like any of us who is just full-time. They've been elected for a full-time representation of our matters in the Parliament. We can even petition for them to go there, and form it. And if they don't, then we do it direct, you see. This is even more important than elected ministers, because this supersedes it. So this is about our rights and liberties in red. And this isn't saying these aren't our rights. It isn't saying our rights start here. This is just itemizing our rights, because then you've got the other bit at the end, which is usually at the start. This is more like this is clarification. And also, you see, because one of the most important things about this is evil judges and ministers. Well, they'd only be being naughty if they weren't representing our interests when we elect them properly in Parliament, or if the judges were prosecuting us unlawfully for matters that we're bringing to the Parliament. Using the judiciary, which during the Civil War there was a lot of misuse of the courts against people and so forth. So that's how I see this set out now. And I think these are clauses, but it's almost a little bit more like the explanatory notes that you usually have at the end, and then the bit here that is at the end now, we have that at the start. This is not to say that these aren't our rights. The whole thing is our rights, because that's what the title of it all is. It's the right of the subjects and liberties. So the whole thing is our rights. Our rights don't start here where it says the subject's rights. This is the context part, really, and then it goes into our rights. And just to decipher our rights, you use this to help add to the context and meaning. That's what I believe, because, like I said, all the official enacting of it now is at the end, which they've put that at the start, and they have the explanatory notes at the end and so forth. Not saying these are just explanatory notes; these are clauses, but these are clauses that are applicable to our rights. These clauses are applicable to our rights. Also, there's something about the clergy in here and the prelates, The prelates also, it talks about the Ased powers. It knows exactly what the Ased powers are. The Ased powers are the immunity when you're prosecuting the government. Those are what the aforementioned Ased powers are with the prelates. And the prelates are the priests, right? The prelates are the priests. Now, some of these priests were getting prosecuted for holding certain religious ceremonies and meetings that the government were prosecuting them for. So the prelates are protected for bringing grievances to Parliament. The priests are protected for, but it says with the aforementioned power, which is the immunity. What's very interesting about these prelates, though, is this: where now, what are the prelates? Which priests are they? Well, in that Scottish Act that we've found out about, it says that there should be no assumed authority above prelates in the church. They shouldn't have a superiority or rank in the church higher than prelates, which is questionable about King Henry VIII making himself head of the church earlier on in this whole story. Like that's with the first Cromwell, not Oliver Cromwell, his ancestor before him. The other act is saying that there shouldn't be any real hierarchy of priests. Now, with priests, either you're ordained or you aren't. If you're an ordained priest, you are ordained. Now, you have archbishops, but, archbishops and so forth. So are the prelates the archbishops and there is nothing higher and they're all set at the equal rank? Or does it mean all ordained persons and priests? The priests are supposed to keep the spiritual morals. So really the priests have a position. And if you actually look at Magna Carta, when you've got the judges going round on the circuits around the country, in the absence of just judges, knights could make orders. Knights could make judgments. So they got a judicial rank and authority, which we don't really use anymore, but they have from Magna Carta. And also the priests. The priests have got a judicial power because they use that judicial power now to marry people. I now join you in holy matrimony. If you want to get divorced, you have to go to a civil court with a judge to annul it. So a priest has power. A lot of priests were involved in the Extinction Rebellion protests and a lot of them got arrested, yet they're ordained and they're meant to have a power almost like a judge or knights and so forth. But here it says the prelates, they also can have the power protected by the aforementioned power, which clearly, what other power is there? This it's all about this protection, this act, the immunity. And I think that the priests really are meant to have a responsibility to make sure that the judges and the ministers are abiding by the law, which they don't seem to do anymore. You can petition about anything. You can even petition about ministers misbehaving or barons or lords and get them to judge each other. The Petitions Committee are trying to stop us mentioning MPs or wrongdoing in petitions when you can actually have it about anything. And if you don't get any judicial action, you can even appeal. The Appeal Act Jurisdiction Act was for pardons or appeals to the House of Lords, which they abolished the Act, but we didn't need the Appeal Act Jurisdiction Act, and we didn't even need the Tumultuous Petitioning Act or this one. There was still petitioning the King before that for pardons or for appeals from judgments and so forth. So the right of the subjects means any subject you want, any matter, any concern. And at the moment, I think the MPs are trying to prevent us from holding them to account. They don't want us to be calling them out on petitions. They're trying to say we can't petition about them doing wrong, when that's one of the main purposes of this act for evil judges and ministers. When our elected ministers are not performing, are not behaving, then we elect them, we can put them in position, and we can petition to remove them or critique them. Also judges as well. But the thing is, the judges can't, the judges, illegal prosecutions by the King's Bench for matters decidable in Parliament. Well, what matters are they deciding? It matters that we've brought by petition, whether there is a Parliament or not, whether his ministers are representing those matters, or whether we've done it directly to the King when there is no Parliament. So that's how I see this. I've put that in red spot there because these are our rights and liberties. These are our rights and liberties. Our rights and liberties don't start here. This is just the title of setting out the rights in clause. This doesn't mean that these aren't our rights and liberties. This is just like the opening piece in context, so forth. They're not explanatory notes, but it's a little bit like the explanatory notes because it helps you clarify what everything's for and why. And then, like I said, the other bit I've left off at the bottom is making it all official and so forth, which you usually have at the start. So that's my interpretation. If you think that I'm wrong, then, it's, where you think that I'm right, then, then you can put that, and where you don't think that I'm right, I guess, that's debatable. But I'm not saying, that I'm 100% right, but this is my feeling on it now after getting all the other information and context. And then you've got stuff like standing armies and so forth. Well, standing army, you can't have an army without people. The government, there's certain legislation and rules for the government forming standing armies, but at the end of the day, who's in the army? It's the subjects, the people. You don't have an army if people don't gather together. But obviously, we can't just come together and say, you can. It says that you've got the right to bear arms for defence, so you can pick up arms if someone's attacking you as an individual. You can defend yourself, but you can't all come together. You can gather peaceably and speak freely, but if you all gather arms and form together as an army, then that's different, isn't it? You're crossing the line then. But certainly, there was a lot of rebellious behaviour going on in public when they were speaking about getting signatures or having meetings and so forth. So I think rebellious behaviour is covered. The thing is, now we've got insurance. There was a lot of people petitioning for compensation from damage that the soldiers were doing or thefts that the soldiers were doing in the Civil War. So they were getting compensated. There were petitions were for, they've stole us artwork. The soldiers came in from the opposition and came in to the village and stole artwork. And then people were getting unjustly prosecuted by courts that were favourable to the Royalists or favourable to the Whigs and so forth. Because when you've got a political conflict, you've already got people who take sides, so they're going to be biased, particularly juries or even judges. And that's one of the reasons why the judges aren't supposed to get involved in political matters, particularly after the Civil War. So I believe that now really everyone's insured. If you put a bank window through, they just get a new window. It's all insured. This is all about, whether they should be prosecuted by the law, criminalised and so forth. So, I know that it's a bit of a tough stretch, but I think that if you can argue those breaking of the window when it's been staged and filmed as an exhibition or an exhibit or representation, even a publicity stunt, you can kind of argue it into that Town and Country Planning Act if it's a representation, if it's been published, with the understanding that the other party's insured and they're going to get it replaced. Although, if something was irreplaceable, maybe like, like some old building or some ancient artifact or something, you're kind of pushing it then. You know, but within things like publishing YouTube videos, saying what you want in a video, free speech, going around asking people to sign, promoting it, and a certain amount of publicisation, taking into account that the public arena now is completely taken over by the corporate elite, and they pretty much have purchased and owned everything to the extent that they've had all their advertising boards installed all down the pavements, all down the streets, everywhere. You can't get away from their promotions and adverts. And if you want to pay to advertise, even for a petition, you're handing money over to them and they're making profit out of it, which is kind of ridiculous. What happened to free ads in the newspaper for lost property, or free ads in the newspaper for petitions? They seem to have kind of like snuck those away now without being biased in the newspaper. You know, it's meant to be there for public notices, as for everyone to use, which is kind of like what YouTube's meant to be. You know, there is a line to draw. For certain, the red line to draw is on the armies and being armed, particularly in England, because we don't really have guns in England, not like in America. So, you know, there's, with the standing armies and so forth, there are lines to draw. I wouldn't advocate anyone just going around and destroying things. So far, all these protest groups, from what I know, none of them have attacked anyone, any person, like, physically attacked them. Or some of the protesters got kicked and punched by members of the public, dragged them out of the road, or I think one of them got pushed over and kicked in the head, but that wasn't the protesters doing it, that was just an aggravated member of the public. So as far as we know, most of the protesters, peaceful protesting, have mainly concentrated on property, which is kind of a little bit like in this whole Civil War context, when these soldiers were raiding people's property at one point, which is quite, in a way, it's sort of similar. So I guess there are some boundaries we've got to define, but as far as I'm concerned, this is what are the requisitions of petitioning, what are required, Most of them are covered and codified in the law, like those Town and Country Planning Acts and so forth. There isn't actually anything specific for police here. So that means that the police, all of the police's permissions, all of the police's acts and actions aren't actually founded on this Bill of Rights for sure. They're only codified into the law, in the modern law. They're put there like, okay, we're going to make it so the police are allowed to, exceed the speed limit, and now we're going to make it into the law that the police are allowed to, kick someone's door down, criminal damage, if they've got a right privilege or interest in a case. It's definitely not based on this. In fact, it's questionable if the police have got a privilege or a right if there's no fundamental underlying institute. Although what that Criminal Law Act said is that, if you're investigating something, no one can hinder or intervene. No one can hinder you or intervene. So it stops anyone from intervening. I guess a prosecution against you would be a form of intervention, though, which is what happened to me when I was investigating illegal road signage, because they took my driving license off me and I couldn't really carry on doing the investigation and so forth. So, and I know you've got to get warrants. The thing is, if someone's having a heart attack or something, you can enter a house to save them. You don't need a warrant from a judge. So there are certain rights, like medical rights. What if someone's in the house and having a heart attack and you see through the window and you just go in without permission and you help them, and then they need to get some tablets and you have to find them and through the house, then you're searching then. You haven't got a warrant from a court. A police officer can't do that on a criminal case without a warrant. But if the person is in immediate need of medical attention, notice that you immediately are having these overriding objectives of saving life, and so forth. But that's the way that you're arguing something then and giving a reason, like you're putting a defence. You're saying, without good reason or an interest in saving life. This is the way that they seem to be doing it in courts, arguing it at the moment. You don't argue this though. This I don't think this right is a reasonable. It's not like you don't reason it or weigh it up or ask what's proportionate or not. I don't think. It says that it's illegal to be prosecuted by the courts, illegal to have prosecutions brought against you for matters that have been brought to Parliament, which means it's already got some proceedings. You're already involved in a case. This is like, injunctions and the needs of other cases. The courts have got to take into account other cases. You would think that if there was something that you'd done wrong in connection with this case has been brought to Parliament, it would be heard and decided along with the matters that you are petitioning about, because it's like the police, there is a judicial, there are these justices and there were grand jury involved and so forth, but they've got rid of that now. So it seems like it's Parliament, and really the Lords are meant to have judicial function. There was committees. They're meant to put together committees for privileges. They've got the Privileges Committee in Parliament, and they've got a Privileges Committee for the House of Lords. Really, those Privileges Committees are not meant to be only for the ministers or the Lords. Whereas our Privileges Committee, really, this petitioning the government, whether or not it's through the ministers or not, or they're representing our case, or they aren't representing our case because there weren't any ministers. It's the same case and it's the same thing, and we don't have a Privileges Committee for us. And if you look at some of the older law, they were putting committees together to hear cases and so forth. That means the immunity will be considered in those cases. And it definitely is not the judges and justices. It would be either the elected ministers or the Lords, or there would be at least some Lords in the committee. I'll link you that information. I've shown you it before, but I'll link it again with this. So that's what I think. And I think that the fact that it's in connection with Parliament, it's proceedings to Parliament, and a proper, it's almost like the Inquiries Act. When you have an inquiry, when a minister has an inquiry, he forms a special court which only has limited powers, certain powers to hear the inquiry, investigative powers. It doesn't have any, it can't make criminal judgments or civil orders. It has investigative powers. The inquiry is formed for that purpose, and if there are any criminal or judicial matters, then it refers them to the Royal Courts of Justice, to the High Court, but not actually to the Magistrate or County Court or to the Crown Court, to the Royal Court, to the High Court. It says, again, I think this Palace of Westminster thing is meant to be the judicial function of Parliament, which they've tried to claim that they've got rid of since the Appeal Act Jurisdiction Act. But there is a judicial responsibility of Parliament in the committee, in the Privileges Committees. So I think that we actually are meant to have a right to the Privileges Committee if there's any questions over, accountability. How it's written out here says you can't be prosecuted. It says all prosecutions are illegal, all of them. So it's suggesting complete and total full immunity as long as it is in connection with bringing these proceedings, starting them, and obviously it goes. Then they're passed on to ministers if Parliament's gathered together. Now, whether or not we can be judged by the Parliament or the committee, barons and lords can be judged by each other, so they're not completely immune when they're in their work. But that was Magna Carta, and Magna Carta, it's questionable whether Magna Carta is in effect. There's a lot of debate on whether Magna Carta is in effect. If Magna Carta isn't in effect, then barons don't have immunity unless it's work for Parliament, and work for Parliament is work for us, because really Parliament is all matters that we elect them and to do for the people. So when we choose to engage with these political proceedings and we're gathering signatures and we're actually bringing evidence and wanting to get it dealt with by Parliament, we have the same immunity as the ministers or the peerage. The question is, this out of Parliament part of it, where there's a requirement to collect signatures, evidence of public concern, get evidence, promote it, let people know about it in order to support it, and so forth. How to what extent are we covered? And this is what we've been arguing through these other papers now, through the Town and Country Planning Act for representations and advertisements, and then we'll go on to YouTube, publishing and promoting, gathering evidence from the public or showing them the preliminary evidence. Petition site, third-party petition sites, they're taking petitions down when they haven't got a right of intervention because it's proper official casework. They want to have a website that hosts your petitions. They can't really, there's not a legal right of intervention. If they want to facilitate it, then they have to, they're just a facilitator. They've got data right protection responsibilities and they've got to maintain the website, but this is protected proceedings. They just can't, they aren't the judge of the case being brought. Parliament is, the King is, or the local council, who are 38 degrees out there to judge your material evidence or even verify the signatures. That's the role of who it's addressed to check it all. And we've got responsibility as well. But this is why, void or spoiled signatures, invalid information is set aside. It's definitely judged by 38 degrees. You see, that's another paper I want to do to 38 degrees. And then there's another issue now with this Stonehenge tunnel where, there's 200,000 signatures to Parliament, but it should have been aimed at the local council because you should have had a local referendum with only 26,000 signatures to get a local referendum to stop the Stonehenge tunnel. And so those signatures are valid with the local council. I've got a case for that quite soon. I want to try to put a complaint into Wiltshire Council about that as well. I guess the other papers are concerning, what's been actually codified into these modern acts, what it can cover. The Criminal Damage Act does cover most acts, all acts, but what the courts are trying to get you to justify or give reason for those acts, when I don't think that it is for the courts. You see, because then the courts are prosecuting you then, aren't they? That's the thing. The thing is, you're ending up with a conviction from the courts for matters that are only decidable and debatable in Parliament, because prosecutions are illegal through the courts, the King's Bench. Convictions, prosecutions, any crimes associated with this petitioning are illegal to be dealt with in the courts. That's what it means. I think that if there is, if we're going to say that it isn't absolute complete immunity, if we're saying that it can be dealt with, then I think it can only be dealt with with the Palace of Westminster, with the committees, with the Privileges Committee, or with the Lords, not the courts. Because the thing is, those juries are made up of members of the public who might be opposed to the cause. They're taking sides, like in the Civil War. It's not when you're bringing a matter and asking the people to sign, right? You're already asking the jury to support not only the information that you're trying with the Palace of Westminster, the case you're bringing, the petition, the information that you're trying to the Palace of Westminster, when they sign the petition and support it, they're supporting what you're doing, your case, your action, and all of it. I believe, which is jury support. And I think that's why you're not meant to be tried in the courts, because it's the people cast their vote whether they support what you're doing or not, and your cause, by signing the petition or not signing it, or even signing an opposing petition. They might sign a petition to oppose what you're doing, but because you can't be prosecuted in the courts, the members of the public who don't agree with it shouldn't be wanting to try you in the courts. And that, I think it said that, didn't it, in Karen's paper? It said that there was members of the public complaining about other people's rebellious behaviour, but then they decided that they were going to uphold the right. So that does actually discount all the rest of the public's opinion of people who choose not to sign or not to support it or choose not to oppose it, or at least, so it at the very least, it's putting all of the facts and circumstances of the case into the Palace of Westminster. And I'll attach that bit that talks about the committees that prove that they were even getting committees before the Tumultuous Petitioning Act. Even actually, I think before this Bill of Rights, and I think before the Tumultuous Petitioning Act. This is before that. So that's before you had immunity. They were putting committees together in the Parliament